Thank you, Jeff. I'm not sure anyone should be scared of someone who's brave enough to go to New Hampshire in, was it January? Yeah, Ken Bishop and I were up there. It was cold. It was snowy. It was scary. I want to give you a legal update on just some selected cases, and I particularly want to focus on one in general. Let me begin with just a caveat. The Surgeon General, or I guess the Attorney General, warning that when I talk about the case that is from a particular state, you still need to listen to your state board's attorney with regard to the interpretation of that case, or for that matter, any case. But their perspective, they are putting it in the context of your laws, your rules, your case, court decisions, that sort of thing, as a caveat in that regard. The second thing is that some of the things I'll be saying today are really unique to a particular case, one in North Carolina, and I want to make it clear that the observations I'm making are not necessarily those of NASBA. They are of concern. They are of concern to each of us. Let me touch, because there is a bit of a theme here in the ones that I've pulled out of the materials. You have a few cases there that are of interest. There have been others that have developed since we had to submit the materials for the binder, and a couple of late developments even on the cases that are there. One of the cases I just mentioned quickly is the National Association of Boards of Pharmacy case. I will not attempt the pronunciation of the other party in that litigation. But that's just of general interest because it involved exam contract, and it involved a situation in which someone who was taking their licensing exam was accused of having cheated on the exam. The National Board pharmacies had evidence they believed was sufficient to justify canceling the grade of the individual that was at issue in this particular matter. And so they did so. The Michigan State Board, however, looked at the same evidence and felt that it was just speculation and conjecture, and did not go along with the National Board's position. Ultimately, the individual that was involved sued the National Association and their executive director, president, CEO, and the board won, in part because the court said that the immunity of the state boards extended by contract to the National Association. That's important because we're parties to a national exam as well. Interesting thing, though, is that that immunity extended even though the state board disagreed with the conclusion that the National Association of Boards had reached. Our situation is different in that by contract and by precedence, the final grade given on exams is still ultimately the responsibility of the state boards. But that immunity there is an important thing, and I'll mention it again as we go further in the discussions. That one is just, again, one to note, but particularly with regard to the importance of immunity and the way that it can extend. The STEP case is interesting for a different reason. That involved a CPA who was charged and found guilty of having engaged in the unauthorized practice of law. The state bar in Delaware went after them and referred the matter to the Board of Accountancy in Delaware. And the Board of Accountancy, based upon the evidence presented, suspended the license of that CPA for a period of time. Then the state's attorney found evidence that the individual was continuing to engage in the practice of law and also accounting, and based upon the information that was out there on the web, referred the matter again, also obtained a cease and desist. That will be an important word later in my presentation as well. In part, the evidence was that they had internet listings. There was some evidence presented by the defendant that they had attempted to get the advertising removed. Nevertheless, the board and ultimately a court as well found that that was not enough. They had not sufficiently complied, and therefore they were sanctioned in that regard. And again, it pertained to internet ads, also Yellow Pages ads as well. But again, note please the cease and desist. Another case, Plude versus Adams. This is probably had some people here squirming a bit and just a bit tired of it too, I'm sure. In that instance, there was an investigation, and the board's attorney recommended that Plude be charged for certain ethical violations. Ultimately, the charges were dismissed, but the individual still sued the board's attorney, the board's executive director, chair of the board, and others, saying that they were wrongfully prosecuted. I believe there were a handful of other allegations in there, defamation and so forth. Again, the suit was dismissed because of the quasi-judicial immunity that the board and its staff enjoyed, and therefore the suit went no further. I will note that one, there is a request for reconsideration by the plaintiff in that case, and there's been a response to the request for reconsideration. As far as I know, as of today, there's been no ruling on the request for reconsideration. Important word there, immunity. Now, immunity works this way, and that is that because you are doing something on behalf of the state, you are working with a state board, a state agency. It's not a private entity unto itself. It may have some of the characteristics of a private entity, but it's not incorporated, it's not chartered. It is created by the state legislature as a state agency to protect the public. And as you hear at these sessions, and no doubt you hear in your ethics training back at your home board, the mission must be public protection, not protection of any competitors or the profession as such. Some of those things may happen along the way, but the objective must be public protection. And for many years, I've stood before you, and occasionally there'd be an antitrust case floating along the way, and I would say, oh, by the way, state boards are immune from antitrust allegations because they are state boards. That's not simply a doctrine, the state action immunity. It is something that is commanded by a thing called the 10th Amendment to the Constitution, that there are certain things that are reserved to the states. And the Supreme Court, for decades, has so held that, in fact, they said they found nothing in the antitrust laws suggesting that they were intended to apply to the actions of states as such. And of course, there are many cases to this effect that state boards, including even 2 cases in particular, accountancy boards are agencies of the state, they are part of the state, and therefore they enjoy that immunity. The board members they're under, because they are doing it on behalf of the state agency, enjoy that immunity as well. Now, that being said, imagine that you are on the North Carolina State Board of Dental Examiners. It was not a client of ours at that time, but they started receiving, almost 10 years ago now, a lot of complaints from various people. Some were dentists, some were hygienists, some were members of the public. And what they were finding was that there were teeth whitening services being opened at malls, at kiosks, or at spas. In kiosks in particular, the concern was they didn't even have running water. And so what were they doing? They were, as it turned out, they were applying whitening products that were many times more powerful than what you might buy, Crest White strips or something like that. They were not self-administered. People were apparently making the molds and putting the chemicals into the mouths of the customers there. So the complaints came out, but basically they were alleging, hey, isn't this an illegal practice of dentistry? Now, the practice of dentistry in many states, including North Carolina, was defined to include the removal of stains from teeth. Now, do a Google search under teeth whitening, stain removal from teeth, you'll find that it pretty much means the same thing. The board kept on receiving those complaints, finally sent an investigator out. The investigator went, sat in the chair, got to a certain point where they said, this is not something I'm willing to do for this job. And what they found was that the individual was about to apply the chemicals, did not have gloves on their hands, and as a matter of fact, had poison ivy. So she said, not going to go there. They would open the cases. They went to court 4 different times, 2 criminally, 2 civilly, successfully, getting people to stop. But the numbers kept on increasing, and so they started sending out cease and desist letters. Now, remember, I mentioned cease and desist letters. Well, the cease and desist letter that I mentioned in the Delaware case was from it was regarding attorneys and the practice of law. That's different, by the way. Can't explain, but it is different. I guess it's because I know the secret handshake. At any rate, so they were sending out cease and desist, and the cease and desist were really, really bad because they said, dear so-and-so, we've received some evidence that you may be engaged in things which could constitute the unlawful practice of dentistry. And they then repeated the statute. And then they asked for cooperation. And then they said that if you are indeed engaged in the practice of dentistry, please stop, because we can seek an injunction or we can even prosecute you. And then the evidence was they sent out 42 of these, and basically none of them ever stopped anyone from doing anything lawful. Everyone seemed to understand it. Nevertheless, it gave rise to something from the Federal Trade Commission. Now, one more little important event that occurred was that you're plugging along, you're doing the best you can, you're sending out cease and desist letters, and then you get a call and someone from the local TV station shows up. And they're wanting to know why you're not protecting the public. And they have there someone who filed their complaint not with the board initially, but with the television station. And it was someone who had gone to a kiosk, had the teeth whitening procedure done, and then went on a cruise. And the second day of the cruise, they had to be dropped off in Mexico because their gums were falling off. That is, yeah. So anyway, this gets the board's attention, and so they are ratcheting up. But almost within days of that, they get contact from the Federal Trade Commission. Now, Federal Trade Commission wears 2 hats. One is to protect America's consumers, and as a matter of fact, that's their motto. If you look on the website, you look in front of their building, that's what they say. They're protecting America's public. Something that the dental board thought it was doing too. But when the FTC gets interested in something, they have broad subpoena power. And they didn't just subpoena the board's records, but the individual board members' records and the individual board members' computers. And then they also went after the records of the State Society of Dentists, and then they went after the ADA as well, and their records, and then they went after the National Society of Dental Boards as well, their NASBA, all having to produce records. Ultimately, when they filed their complaint, they alleged that the board, because it was comprised of a majority of licensees, that is, the majority of the members of the board were licensed dentists, that it was an antitrust conspiracy on its face, in and of itself, and that it didn't, ultimately, that it did not even matter that the statute was clear. Now, bear in mind that you're a board member, and how many of you take an oath before you, or at least sign something notarized before you become a member? I think almost all do. And so, and part of that is you're answering, yes, I will enforce the laws of this state. So board members take an oath to say they're going to enforce the law. The law says removal of stains from teeth is the practice of dentistry, and you're supposed to prevent the unauthorized practice of dentistry. So they understood that. Majority of the board members, yes, they were licensees, but the majority at no time were individual dentists that were engaged in the teeth whitening aspect of the practice of dentistry. That was not what they did. But at any rate, the FTC says that it was an antitrust conspiracy on the face of things, and that it didn't matter about the clarity of the statute. It seemed outrageous enough that we helped the board out. We advanced it. We thought that we could get it knocked out in early stages of dismiss, but the Federal Trade Commission was on a different mission altogether. It had announced, it had been fairly transparent in terms of its plans of extending its authority in this regard. What happened 4 or 5 years ago was, remember, there was created this new commercial finance public protection agency, and that agency, FTC, members of the FTC appeared opposing the establishment of that agency because it was taking away some of their turf. At any rate, it was created, and a lot of what the FTC had been doing in that regard was no longer theirs to be done. And so at around the same time, they embarked upon a study to determine whether or not they could open up new thresholds, new areas of antitrust inquiry, and one of them in particular was with regard to the extent to which state action immunity would protect state licensing boards, professional licensing boards. And this was their first direct foray in. They had sent out letters to others, but this was the first direct foray into this area. The upshot of it is that things didn't go right in terms of the FTC. Guess what? They ruled on their own complaint. They felt they were not biased in the complaint. They ruled on it. They said that they had jurisdiction. They denied the board's request for a change of venue so that it could be heard in North Carolina. We know of states, all of us do, where board members are prohibited from traveling out of state with regard to board business. In this instance, times being tight. In this instance, the FTC mandated that the hearing be held in Washington, D.C. at their convenience. 5-week hearing. Put that on your calendars. And then at the end of the day, notwithstanding no evidence whatsoever that the board members expressed any intent to control a market, did anything other than enforce a statute, no evidence that anyone was ever stopped from doing something that was lawful under North Carolina law, the FTC even conceding that the statute involved may have been, they weaseled a bit, but may have been clearly articulated and therefore was plain enough to be enforced. They rested a lot on the cease and desist letters. They said that the board had no immunity, that it was operating as on behalf of the dentists of North Carolina engaged in a conspiracy to restrain trade, and acted accordingly, issued the order. That was appealed, and we had some hope, but it's been tough sledding so far. The Fourth Circuit recently, after we submitted materials for the binder, issued their decision supporting the Federal Trade Commission, saying that the state had no immunity in this instance. They hung up on the fact that the majority of the board members were licensees, and that did not look at any intent. In fact, the concurring opinion, it was a 3-0 decision, but one of the decisions was a concurring decision. In that decision, the judge even said, and this is, they were trying to be nice, but it worries, this part worries me most, said, the record supports the board's argument that there is a safety risk inherent in allowing certain individuals who are not licensed dentists, particularly male kiosk employees, to perform teeth whitening services. And yet, they ruled against the board, saying that public protection was not enough. That in and of itself was not going to carry the day, that you had a per se conspiracy. Now think just for a moment in our little world here, where they would go potentially, and there are differences, there are defenses, and the case isn't over. The board likely will seek a rehearing, and then if that doesn't work, we'll likely ask the Supreme Court to look at it. Supreme Court's never ruled against this issue. We'll see. But think about it in our context. What is the definition of what only CPAs can do? It is defined by what are included in standards. It says that a test, and if you unless you're licensed, you can't do a test. And the definition of a test says it's related directly to certain standards. And then, in passing, I note that those standards can change almost overnight. And most recently, ironically, the standards changed by removing SAS 70 over in the SSAE. And as a result, the SAS 70 services were suddenly no longer in the definition of a test for the states that adopted the purely worded UAA. NASBA helped. We sent out an immediate fix. Everyone understood the public protection concerns. The other way, though, the other way to look at it is you can add services in. SSAE, add services in. And so if I'm a cynical FTC enforcer and I'm looking at the situation, I've got standards here. They're established by the way you ascertain whether or not a CPA can do it, or only a CPA can do it, is by reference to the standards. The standards are adopted by a private trade association comprised of competitors. That may not be the place that we want to hide. That may not be the immunity that we need, if this case ultimately stands for all the propositions that it now stands for. It could be limited, it could be reversed along the way. But it's a wake-up call. Sarbanes-Oxley 209 seems to say that it's the state board's job to be determining what standards are applying to practitioners. We need to be careful in that regard. We have a wonderful, long-standing working relationship between the state boards, the state societies, the National Association of State Boards of Accountancy, and the AICPA as well, doing critical things today on the contract, on the exam contract, on the Uniform Accountancy Act. Very important things working together, and have a wonderful legacy of working together. But we do need to be careful and not let our friends go out on that limb too far, because there are risks involved. The antitrust laws in this state are not just the inconvenience of a 5-week trial in Washington, D.C., which was a 3.5-hour drive for those from North Carolina, but is going to be a longer walk for a lot of y'all. It is that same laws create the right of private action and treble damages and attorney's fees. In fact, those same laws even are criminal. They're felonies if you're found guilty of the wrongdoing. So this is a law development that we'll continue to watch. There are many amicus briefs that were filed in the Fourth Circuit. I'm sure there'll be interest ongoing, has already been expressed as we watch going forward. The stakes are high because they have a lot to do not only with all the ugly sides of a loss of immunity, but also the loss of the importance of public protection. You know, when you come on go on your board, you not only take an oath to support the law, you go through a battery now of ethics questionnaires. Many of you now have to read at the beginning of every meeting, a conflicts of interest statement, and saying you will not engage in a conflict of interest in any vote, not just ethics or disciplinary cases. But the implications of this case are broad. They could change who's here at the meeting next year if it goes to the heart of the matter of who can even serve on these boards or what degree of supervision has to apply there. There are exceptions, there are angles at it, there are ways to look at it in a more favorable light, but the implications are broad. Remember again, cease and desist, sounded good there? Interesting. What could be done there, and the risk involved. Immunity, sounds good here, sounds good there. Under this approach of the FTC, they're saying that because it was comprised of a majority of licensees, that it didn't wear that cloak of the state. The immunity wasn't there. Well, thank you very much.